that is revoked, a will that is revoked, that you want to bring back to life, that is revival of a will. Now, you can bring back to life a will that has been revoked if it has not been destroyed, animus revocandi. A will that has been destroyed, animus revocandi, can be brought back, cannot be brought back to life. You cannot revive it. But if you have revoked a will in any other form, in any other way, you can revive it. So the point I'm making here is that if your will has been revoked by destruction, animals or animals revocandi, you cannot revive it. But a will revoked in any other manner, if you have revoked your will in any other manner, you can revive it in either of these two ways, provided in provision of Section 15 of the Wills Law of Lagos State, Section 22 of the Wills Act 1837, and Section 19 of the Wills Law of Western Region 1958. Those two means include: one, re-execution of the will by the testator. When you execute the will by the testator, when the testator re-execute the will. Number two, by a codicil executed by the testator in the required form, showing a clear intention to revive the will. So the basic gist about revival, the gist about revival of a will is that if your will has been revoked, animo revocandi, you cannot revive it. There's nothing you can do to revive it. But if your revocation of the will is due to other means, or has taken some other means, or if there is the will has been revoked by means other than the one destroyed, animo revocandi, then you can still revive it. And the way by which, two ways by which you can do that, is to re-execute the said will. The testator will execute the said will, or he will do a codicil. Are we together? He will do a codicil, which will show that he has an intention to revive the will. So this is provided for in Section 15 of the Wills Law of Lagos State, Section 22 of the Wills Act 1837, and Section 19 of the Wills Law of Western Region. You can also see the case of Rogers and Goodenough. Rogers against Goodenough, to further illustrate what we are talking about, revival. Now, the other one that we need to note is what we call republication. What we call republication. Republication. Of course, what republication talks about is that it is more or less what we could call re-establishment. To re-establish, republication means to re-establish the validity of a previously revoked will, to establish what? The validity of a previously revoked will by repeating the formalities of execution only using codicil. Only using codicil. It lies in the re-establishment of the validity of the previously revoked will by repeating the formalities of execution only using codicil. You can check the provision, you can check page 466 of the revised edition, Laws of Succession in Nigeria, Principles, Cases, and Practice, by Professor Babatunde Adetunji Oni, SCN, in page 466. So, where it's talking about republication, it's talking about republication. Remember that I have told you that revival does take the form of re-execution of the will by the testator, or doing a codicil that is executed by the testator in the required form, showing a clear intention to revive the will that have been revoked, but not by destruction, animus revocandi. So if your will has been revoked by destruction, animus revocandi, you cannot revive it. But if it has been revoked by any other means, the provision of section, section 15 of Wills Law of Lagos State and section 20 of Wills Law of Wills Act and section 19 of Wills Law of 1958 of Western Region is that you can revive a will that has been revoked if it is not revoked by destruction, animal vacandi, by doing any of the following. One, by a re-execution of the will by the testator, you re-execute the will. Two, you could by a codicil executed by the testator in the required form, showing a clear intention to revive the will. So I go back to the publication after having emphasized on what is revival. The publication lies in the re-establishment of the validity of a previously revoked will by repeating formalities of execution only using codicil. Of course, the result is to make the old will effective from the date of republication, to make it effective from the date of republication. It is also termed revalidation or confirmation. The testator may confirm a will or may confirm a codicil. Now, the difference between revival and then republication is that revival brings back to life a revoked will or codicil, whereas republication confirms and revalidates an unrevoked will or codicil. So I take it again that republication lies in the re-establishment of the validity of the previously revoked will by repeating the formalities of execution only using codicil. Therefore, the result, is to make the old will effective from the date of republication. It is also termed revalidation or confirmation. And then, of course, a testator may confirm a will or a codicil. But there's a difference between revival and republication. And that difference is that while revival brings back to life a revoked will or codicil, the republication confirms or revalidates an unrevoked will or codicil. Of course, republication can be inferred from the mere reference to a will or a codicil. So now, that having been said, a will can be republished. A will can be republished where the testator intends to show that his previous will is unaltered. It can be republished where he wants to show that his previous will is unaltered, or where the testator wishes to validate an alteration in the previous will. He wants to show, the publication will assist the testator to show that my will is unaltered, or that the alteration that you find in the previous will, they are valid, or that I intend to validate those alterations. You can see the case of Rehay. In Rehay, a testatrix who had struck out 3 legacies in her will. Of course, the striking out of the legacies were unattested. They were unattested. Later in a codicil subsequently made, revoke only one of those 3 legacies struck out in the will. The will was held to have, confirmed the codicil as being without any alteration. So, what is the effect of, republication? It should be noted that section 34 would apply to republication as well. Generally, a republished or revalidated will operate as if it has been, executed at the time of its republication. So you can see the case of Remor. See also goods of Rawlings, Remor and goods of Rawlings. Now, section 15 of Wills Act deprives an attesting witness and his spouse of any benefit under a gift in the will. But if the will is confirmed by codicil that is not attested by that witness, this validates the gift. It validates the gift. Validate the gift. So I'll repeat myself regarding republication. Republication, like I mentioned, is the reestablishment of the validity of a previously revoked, you know, 1 minute, please. Hello, are we there? Hello, hello.
With you.
Okay, please give me 1 minute, please. I'll be back with you.
Yes, sir. We are with you.
I'll be back with you in 1 minute, please. Hello, hello, hello.
Hello, sir.
Hello.
Hello,
Okay.
sir.
Okay, there is one point that I need to call your attention to, which is the fact that republication has the effect of taking place, or rather, sorry, taking effect from the date of that, from the date that republication is made. You can see Remo and then see the, you know, see the goods of Rawlins. Rawlins is spelled R-A-W-I-I-N, sorry, R-A-W-L-I-N-S, Rawlins, without G. So I also mentioned to you that Section 15 of the Wills Act deprives an attesting witness and a spouse of any benefit under a gift in the will. But if the will is confirmed by a codicil, not attested by that witness, then the gift will be validated. Now, what about codicil? Codicil tells us that it is more or less a testamentary document. It's a testamentary document similar to, but not necessarily the same thing as a will. Of course, codicil may serve the purpose of amending, rather than replacing a previously executed will. I repeat myself, codicil is a testamentary document which is similar to, to a will, but not necessarily the same. Of course, in some jurisdiction, it could serve the purpose of amending or kind of replace a previously executed will. In other words, it will serve as alternative to a will, maybe an alternative to a will. The codicil, when you want to lodge it and want to execute it, it takes the same procedure that you apply to making and then lodging of a will. So a codicil, of course, as defined by Black Law Dictionary, the 8th edition in page 275, tells us that to mean, it tells us that it means supplementary or more or less an addition to a will, not necessarily disposing of the entire estate, but modifying, explaining, otherwise qualifying the will in some ways. I repeat myself, that a will is defined in Black's Law Dictionary, 8th edition, page 275, to mean a supplementary or addition to a will, not necessarily disposing of the entire estate, but modifying and explaining or otherwise qualifying the will in some ways. You can see the case of Atoe another and Atoe others. Atoe is spelled A-T-T-O-E and another against Atoe and others. So now that having been said, there could be several codicils. Please note. However, there can be only a single will. It is advisable for us that where a testator has made several codicils, a new will should be made, revoking the previous codicil made in order to avoid any controversy that might arise, in the will being declared invalid or set aside. So when you have made several codicils, it is better for you to make a new will, that will revoke all the previous codicils, made in order to avoid any controversy that may arise in the event that that may arise in the will being declared invalid or set aside. So the important thing, another important thing that you need to note is that codicil also has the same conditions that a will has, without which it will be declared invalid. Remember that for a will, you must have attained the statutory age of making a will before you can make one. Of course, it must be in written form, and there must be due execution. Of course, you must also have testamentary capacity, and then there must be animals. That is the intention to make the will. Of course, in clear terms, we must know that there are some similarities between a will and codicil. The differences between will and codicil include the fact that there cannot be a codicil without a will first being made. You can't make a codicil without a will first being made. And also, a codicil is simply an amendment to an existing will. You cannot have a codicil without a will first being made. And then basically, a codicil is an amendment to an existing will. Of course, the second difference is that the codicil may involve only changes or deletion to a will. Only changes or addition to a will. And note also that a codicil is dependent on a will. Now, the similarities that we have in a will and codicil include the fact that the will and subsequent codicil are more or less or oftentimes interconnected. Same requirements are required, same requirements that are applicable to both will and then codicil. For example, in a valid will must be signed by testator in the presence of two witnesses. Therefore, a codicil will likewise have to be signed in the presence of two witnesses by a testator. The third similarities I find there is that they are both testamentary documents and they are capable of being revoked. Yes, that having been said, when is it preferred? When is it preferable to make a new will instead of a codicil? Of course, as relevant as a codicil is for as relevant as we find codicil for revocation, amendment, alteration, revival, the publication of a will, there are certain circumstances. That making a will be the best. One is where where there's a substantial change in the financial status of the testator. Of course, two, where there's a change in the membership of the family. For example, the family of the testator has become expanded. Maybe they have given birth to a new baby, or there's adoption of new children. Of course, this will necessitate more or less executing another will. Then regarding this financial status, the testator may become richer than he was at the time of making the will, and that what this means is that it will be required, or rather, it will have acquired more properties which are to be distributed. Of course, it will be best to be in the best interest of that testator to execute another will. Of course, another circumstance where it would be nice for you to make another will is where a man gets married after making a will or divorced or is separated from his wife. Of course, again, number 4 is, when there's a change in your permanent residence, when there's a change in permanent residence of the testator. Of course, a change in residence of the testator will also necessitate, writing, another will to reflect the change in place of domicile and to accommodate the properties that may be acquired in that new place of abode. Of course, the testator would be expected to make a new will to take care of this situation. So circumstances that will require that you make a new will include when you have a substantial change in your financial status, when there is a change in the membership of the family, where a man gets married after making a will or is divorced or separated from his wife, where there's a change in permanent residence of testator. And I mentioned to you that you will find some differences between codicil and will, because as far as codicil is concerned, codicil cannot be without a will first being made, and that codicil is simply to amend the existing will. And a codicil, like we mentioned, may involve only changes or deletion to a will, and then it's also dependent on a will. I remember that I mentioned that there are some similarity between codicil and will to the extent that the original will and subsequent codicil are sometimes interconnected, and that same requirements are applicable to both will and then codicil. And then, for example, in most jurisdictions, we find that the will must be executed, by testator in the presence of two witnesses, and therefore a codicil would also be expected to be executed or signed in the presence of two witnesses, and that both are testamentary documents which are capable of being revoked. Now, what are the functions of codicil? Now, you can use codicil to appoint an executor or trustee, appointing an executor and trustee in codicil in the substitution for executor and trustee who has died. So you can use codicil to do what? To appoint an executor and trustees, in substitution for executors or trustees who have died Also, you can use, codicil to make a gift or advance, to a child. You can also use codicil on the occasion where testator's second marriage, you can use codicil on the occasion of testator's second marriage, 2, reviving his will, substitute the names of his second wife for the first, and including any children by his second wife in the gift, so that you can take care of the children of the subsequent wife. I think I've mentioned this, in passing. You can also use to correct clerical errors in your will. You can use, codicil to render valid alterations that you have made in your particular will. And you can also use, codicil to republish a faulty will. Those are things that you need to know about codicil. Let us also try to talk about the classification of gift here, and then we can move on to other things from there. Now, when we talk about gift, in a will as provided by the testator are usually referred to as legacy. Gift in a will, as provided for by testator in a will are usually regarded as or described as legacy. They are referred to as legacy. So when you find the word legacy, what you get to know is that it is called legacy. So legacy is more or less equal to gift. And then there are many types of legacy that one can have. One is specific legacy, the other one is general legacy, and then you can also have demonstrative legacy. You can have pecuniary and then residuary legacy. Of course, one can also say that how a gift is treated, or to be applied in various categories. How a gift is treated or how it to be applied in various categories would suggest, the class of legacy it is to be referred to. Now, so I've said two things. gifts in a will, as provided by the testator, are referred to as legacies, and there are many types of legacies, and the legacy could be specific, could be general, could be demonstrative, could be pecuniary, or could be residuary. And then we can also say that how a gift is treated or to be applied in various categories would suggest the class of legacy it could be referred to. Now, a gift to, please note, a gift to a professional, personal representative for his expertise is regarded as legacy of cost. Legacy of cost, then legacy may be conditional and sometimes may be absolute. Of course, it is conditional if some conditions are specified for taking such gift, and absolute if it is otherwise. Now, specific legacy, please note that specific legacy, is the gift of a particular piece, is the gift of a particular piece of testator's personal property. Specific legacy is what is the gift of a particular piece of the testator's personal property. Specific legacy is the gift of a particular piece of the testator's personal property. And I repeat again, the specific legacy is the gift of a particular piece of the testator's personal property. Of course, specific legacy may be specific legacy may be described by the use of the word mine. If you find mine in a gift, we will find that that person is more or less making a specific legacy. So specific legacy may be described by the use of the word mine when the gift is being indicated. However, where the testator describes the gift, where the testator describes the same gift as a general gift, it will not, constitute a specific gift. Where I describe it as a general gift, it will not constitute a specific gift. So I'm saying that legacy that is specific is a gift of particular piece of the testator's personal property, and the specific legacy may be described by the use of the word mine when the gift is being indicated, the inclusion of the word mine. However, where the testator describes the same gift as general gift, it will not qualify or it will not constitute a special gift. So now you can see the case of Compton. Compton is spelled C-O-M-T-O-N. Where in the case of Recompton, the testator made a gift of all my shares of stock in Midland Railway Company. It was held to be a specific legacy. Now, a specific legacy is distinct and more or less separated from the whole personal property of the testator, or the whole of the general residue of his personal estate. So what I'm trying to say, in essence, is that when you have a specific legacy, it is more or less a particular piece of the testator's personal property, and a specific legacy may be described by the use of the word mine when the gift is being indicated. However, where the testator has actually described the same specific legacy as a general gift, it will not constitute a specific gift again. See the case of Compton. Compton is spelled C-O-M-P-T-O-N. Now, where the testator made a gift of all my shares, the gift of all my shares of stock in Midland Railway Corporation. Court held that it was a specific legacy. Are we together? You can also see the will of the case of Bothamley and Sharon. Bothamley is spelled B-O-T-H-A-M-L-E-Y, and then Sharon is spelled S-H-E-R-O-N. See the case of Bothamley and Sharon to support the position in Compton, in the Recompton. Now, a specific legacy is distinct and separate, and is separated from the whole of the personal property of the testator or the whole of the general residue of his personal estate. Please note that very importantly. The characteristics of a specific legacy include the following. The characteristics of a specific legacy include the following. One, it is always particular. It's always referring to a particular piece of the testator's personal property. One, it must be specific. It must be distinct, separate, and distinguishable from other property. It must be what? Specific, distinct, separate, and distinguishable from other properties. Number three, the description must be ascertainable from other similar types of gifts, other similar types of same gifts. Now, where a will has not properly drafted, where a will, has not been properly drafted to take care of the doctrine of redemption. The doctrine of redemption is that a gift that has been lost or which does not belong to the testator again. So if a gift has been redeemed and then you have not drafted the will to take care of this issue, once a specific legacy cannot be found at the death of the testator, or if the testator has sold the gift during the lifetime and at the time cannot be found, or rather the item cannot be found, the gift is deemed, the beneficiary of such gift takes nothing without compensation. So please, you need to be very careful as a lawyer. Redemption is what you need to look for. You need to be cater for when you are making a gift of specific legacy, or you are giving a specific legacy. Because the position here is that where a will does not properly, is not properly drafted to take care of the doctrine of redemption, redemption takes place where the testator probably have lost the gift, he has sold it, or something has happened to the gift that no longer exists. Now, once a specific legacy cannot be found at the death of the testator, of course, if the testator, possibly has sold the gift during his lifetime, or the item cannot be found, then what it means is that the beneficiary will not take anything. But a lawyer who is drafting a will can take care of this redemption, in a specific legacy, and then they advise, and then they could explain, they can advise and explain the doctrine of redemption to their client, and then, and the way they affect, and the way it affects specific legacy. Of course, the will can therefore be drafted in a way that beneficiary could be compensated if the specific fails, the specific gift, specific legacy, if it fails, either with another gift, or with another monetary compensation. So what I'm trying to say is that to take care of redemption, or a gift that may likely be redeemed, such that they will not affect specific legacy, you can advise your client on it. You can then also explain what it means to them, and then by so doing, you can draft, a will that would make it possible for the beneficiary to either be compensated money or be given another gift in the event that the specific gift is redeemed. So a good example of how to draft such a clause in the will could be found in the book of Professor Oni, SCN, in page 476, where it says that I give my customized gold necklace purchased in Dubai to my son, Eric, but where the necklace cannot be found, at my death, my personal representative shall produce the same necklace from my vendor in Dubai, or give him the value in money. So that's a way to save a gift from being redeemed. Now the advantage of specific legacy is that against a general legacy that will abate. You know what it means for a gift to abate. To abate means to be reduced. That will abate. While if the estate is insolvent, a specific legacy will not. Please, the advantage of specific legacy is that, if you compare it against the general legacy, that will generally abate when the estate is insolvent. The specific legacy will not abate. Of course, the value of the specific legacy accrues from the death of the testator. The value of the specific legacy accrues from the death of the testator. The second one is general legacy. When we talk about general legacy, this one does not refer to any particular piece of testator's estate. It does not refer to any particular piece of testator's estate. Of course, it is a gift of property which is neither distinctive nor distinguishable like a specific legacy in the will. I take that again. When we talk about general legacy, it does not refer to any particular piece of testator's estate. Does not refer to any particular piece of testator's estate. It is a gift of property which is neither distinctive nor distinguishable, like we have in the case of specific legacy in a will. Example of a general legacy are gifts of stocks and shares, not putting mine, gifts of stocks and shares, although they may be made specific if the testator describes them as my share in a particular company. I give one of my Toyota car to my son, Eric. I give my furniture to Dio. So what I'm trying to say in essence is that the word mine will make, when you use the word mine in giving a particular piece of your estate as a testator in your will, then that means that you are creating a specific legacy. Now, if you don't use that word, you don't make it specific. So it says that example of general legacy are gifts of stock and shares, although they may be made specific if the testator describes them as as such. Now, when we talk about gifts in a general legacy, they are not distinctive in the sense that there could be many Toyota cars and then different types of ownership. Of course, the advantage of general legacy is that where the testator left sufficient assets, it becomes easier for the personal representative to give out the gift to beneficiaries. So now, the next one is that we talk about demonstrative legacy. Demonstrative legacy. Now, demonstrative legacies are legacies that the testator directs to be satisfied out of a specified fund or a pool of property. And a good example of demonstrative legacy is that a sum of money be paid out of a particular bank account. For example, I give 500,000 to Jumai for my current account with Diamond Bank, or I give 1 million naira to Tayo for my pension, account with Stanbic Bank PLC. Now, demonstrative legacies operate as a specific legacy unless they fail because the specific property is not available. You will see that it's similar to specific legacy. Demonstrative legacies operate as specific legacies unless they fail because the specific property is not available. So, however, where it fails as a specific property, it takes effect as a general legacy. You can see the case of the Webster, where the testator gave the legacy of the sum to be paid out of his shares in the family business. This was held to be a demonstrative legacy. You can also see the case of Watford, where the testator gave his sister a sum of money to be paid out of the estate, and then in fact inherited by him from his mother. Of course, the court held that the legacy was demonstrative, irrespective of the fact that it was to be paid from some, to be received later. So now, the point I'm trying to say in essence is that demonstrative legacies are said that there are legacies that are paid from a particular account or from a particular property or pools of property, and then examples have been given in the precedent that we discussed before. Now, we say that demonstrative legacies, they have two major advantages. Of course, if it is not caused by doctrine of redemption as a result of either total or partial failure of the gift at the death of the testator, of course, it becomes payable from general personal estate. So what we are trying to say is that demonstrative legacies have two, major advantages. If it is not caused by doctrine of redemption as a result of either total or partial failure of the gift at death of the testator, it becomes payable from general personal estate. So secondly, it is payable tense at the death of the testator, except where the testator intention is that the fund must be paid from that particular account. It is advisable, therefore, for a lawyer when drafting demonstrative legacy, to take into consideration an alternative source of money in the case there is an insufficient fund or non-existence of the account at the time of the death. I'll repeat the advantages again, that demonstrative legacies has two advantages. Please note very importantly. One, if not caught by doctrine of redemption as a result of their total, or partial failure of the gift at the death of the testator, it becomes payable from general personal estate. Of course, notwithstanding that they have mentioned that pay from this account. Of course, if they can't find money there, they could go to other parts of the general estate to get the money paid. Secondly, the legacy is still payable. The legacy is still payable, whether or not the fund from which it is payable is in existence at the death of the testator, except where the testator intention is that the fund must be from the particular account. Of course, because of this, it is therefore advisable that a lawyer, drafting a demonstrative legacy should take into consideration an alternative source of money in the case there is an insufficient fund or non-existence of the account at the death of the testator. So, to that extent, an example of a good demonstrative legacy is given below. And it says, I give the sum of 1 million naira in my current account with Diamond Bank, Bodija branch, Ibadan, to my son, Eric. If on my death, there is no sufficient fund in the said account or no longer in existence, gift shall not lapse. My executor or trustees shall meet the legacy from any other account operated by me, provided that in the case of insufficient fund, whatever is available shall be paid to them, shall be paid to him in full and final settlement of his legacy, of this legacy. I repeat the example. I give the sum of 1 million naira in my current account with Diamond Bank, Bodija branch, Ibadan, to my son, Eric. If on my death, there is no sufficient fund in the said account or no longer in existence, gift shall not lapse. My executor trustees shall meet the legacy from any other account operated by me, provided that in case of insufficient fund, whatever is available shall be paid to him and in full and final settlement of this legacy. Now, pecuniary legacy is the next one that we need to look at. Now, when we talk about pecuniary, please, are we together? Hello? Hello? Hello?
Yes, sir.
Yes, sir.
Okay. Are you getting the point? Can I continue?
Yes, sir.
Yes.
Okay. Now, when we talk about pecuniary legacy is saying that, it is primarily a gift of money. A gift of money. You can see, demonstrative say paid from a particular source. Specific say my particular share. While general says that, of course, that one is just is not talking about particular piece of the estate of of the testator. But here they are saying that if it is pecuniary, then it is a gift of money, which may be specific. You can make that gift of money to be specific, general, or demonstrative. Of course, a pecuniary gift of money in a testator's piggy bank, may be construed as a specific gift, which will fail if there is nothing there. Are we together? There is nothing there. Also, a general pecuniary gift is a sum of money, and also that is when you say a sum of money becomes general. A demonstrative one is directed to be paid from a particular fund. See the case of O'Connor, Ri O'Connor, C-O-R-I O'Connor. O'Connor is spelled O with apostrophe, C-O-N-N-O-R. Of course, where it was held that the term pecuniary legacy is not, is not appropriate in the said gift. However, Section 1 of the Admission of Estate Law. Before I go back to Section 1 of the Admission of Estate Law, I repeat what pecuniary legacy is all about. It is primarily a gift of money, and then it could be specific, it could be general, it could be demonstrative. And if a gift is pecuniary, and then what it means that and it says that it's pecuniary, and it says that the money in a particular piggy bank belonging to the testator, this will be considered as specific pecuniary gift, which will fail if there is nothing found there. Then a general pecuniary legacy, a general pecuniary gift, is a sum of money, generally just a sum of money, where demonstrative one is saying that you pay from a particular fund. However, Section 1 of the Administration of Estate Law of Lagos State, of Lagos State, yes. Section 1 of the Administration of Estate Law of Lagos State, and also Section 1 of the Section 1 of the Administration of Estate Law of Lagos State. Of Lagos State. Yes, of Lagos State. Now, says that they define a pecuniary legacy to include an annuity, pecuniary legacy. You know what is annuity? Money that is paid at intervals, at a particular interval. So to include annuity and a general legacy, and a general legacy and a demonstrative legacy, so far as it is not discharged out of the designated property, and any other general direction by the testator for the repayment of the money, including all debt duties, free from which any device, bequest, or payment is made to take effect. So all this we are saying is just to say that annuity will also qualify as pecuniary legacy. Annuity will also do what? Qualify as pecuniary legacy. You can see, Real of Beckley. Real of Beckley. L of Beckley is spelled, Real of Beckley is spelled EARL of Beckley. Beckley is spelled BERKELEY. So the summary of what I'm saying here is that pecuniary legacy is a gift of money. The gift of money could be specific, it could be general, it could be demonstrative. It is specific if you say the testator's money contained in the piggy bank, which will become specific and will be lost if nothing is found there. It's general if it's just a gift of money. It's demonstrative if that gift of money is to be paid from a particular fund. And I mentioned to you that Section 1 of the Administration of Estate Law of Lagos State also says that annuity payable to anybody is also it will also qualify as a pecuniary legacy. You can see the case of L of Beckley to substantiate the point about annuity being part of pecuniary legacy. If you allow me, I'll move on to residuary legacy. Residuary legacy or gift refers to the unappropriated residue of the estate of the testator. The residual legacy is the unappropriated. The gift, refers to the unappropriated residue of the estate of the testator. So when we talk about residuary legacy, it is the part of that estate that has not been appropriated, part of the estate of the testator that has not been appropriated in the will is called the unappropriated residue of the estate of the testator. I repeat myself, residuary legacy or gift refers to the unappropriated residue of the estate of the testator. Of course, it is what is left. It is usually what is left, after gift giving, after all the gift giving, after the gift given by the gift, after all the gift given by the testator in his will, or codicil has been appropriated and satisfied. It is what is left after all the gifts given, by the testator in his will or codicil have been appropriated and satisfied. Of course, that agrees with that definition that we give earlier, that it refers to the unappropriated residue of the testator's estate. And I mentioned to you that it is what is left, it is the gift that is left after giving, what the testator what has been given, what the testator has given in his will or codicil have been, appropriately appropriated and satisfied. Of course, it also refers to gift. It also refers to gift and legacies that cannot be appropriated for one reason or the other. The unappropriated gift, the unappropriated part of the estate, and the part of the estate that is incapable of being appropriated. Of course, every properly drafted will should have a provision for the application of a residue, preferably for one, which foresees all reasonable possible events of failure, such as divorce, are you together? or where the gift has lapsed, or where you talk about predeceasing. So they are saying that residuary legacy refers to those part of the estate that has not been appropriated, and those ones that are not capable of being appropriated by virtue of predeceasing, divorce, or lapse of gifts. Section 20 of which has made provision for for residuary disposition, and that the following constitute where a gift may fail. Not one, circumstances when a gift may fail include ademption. I have mentioned to you what's an ademption. Ademption, defines as the destruction or the extinction of a testamentary gift by reason of a bequeathed asset ceasing to be part of the estate of the testator at the time of death. Of course, ademption also occurs where a property has been sold, where it has been destroyed, or given away before the testator's death. Of course, the doctrine of ademption, was conceived in equity so that those to whom testator stood in locus parentis should not, at the expense of the other, take double portion. Now, what are the exceptions to the doctrine of ademption? Remember, we said that a gift may fail if there's an ademption, and then, there are other circumstances that can lead to failure of a gift. Remember that I told you that when we say that we talk about residuary gift, it relates to the unappropriated part of the estate of the testator, or the part of the estate of the testator that's not capable of being appropriated by virtue of ademption, failure of such gift, or divorce, predeceasing, or or that the gift has actually lapsed. Now, when we talk about ademption, which would always apply where the gift is no longer in existence at the time of the death of the testator, maybe it has been sold, or maybe something else has happened to it, or it has been destroyed. Now, we talk about exemption. We talk about ademption, but with some exceptions. Exceptions to ademption can happen where, one, the gift has been removed by fraud, or by the tortious act, which is unknown to the will maker, unknown to the testator. So an ademption of a doctrine of ademption will not apply, even though the gift is no longer found, because where it has happened that the gift was removed by fraud or by a tortious act that's unknown to the testator, then ademption will not apply. Where an agent has disposed of the gift, the subject of the bequest, outside the terms of agency and without the knowledge of the testator, ademption will not apply. You cannot come and say that the gift is no longer found. The gift has been destroyed, or it's not part of the estate. But the law is telling us that if it can be found, if it can be established that what led to ademption was the removal by fraud or by tortious act of another person who is unknown to the will maker or the testator, then that ademption will not apply to that gift. Now, where an agent has disposed of the gift, the subject of bequest, outside the terms of agency and without the knowledge of the testator, ademption will also not apply. That is, the agent has actually acted in excess of the authority given to him to sell the property or to take it away from the kitty. Now, thirdly, where the gift is still in the estate, in substance, although change in name or in form. So, for example, where money has moved from one bank account to another, or stock or shares have been subjected to a corporate name change. So, if the gift is still within the estate, but the substance has changed, the gift is still in the estate in substance, but there is a change in the name and form. The substance has not changed, but there's a change in form and name. For example, the money is there, but it has been moved from one account to another, and you can trace it, or that the stock or shares have been subject to a corporate name change. Then the ademption will not apply. Ademption, like I mentioned to you, will not be exempted. A gift will be exempted from ademption where the gift has been removed gift has been removed. The gift has been removed by fraud or by tortious act that is of another person unknown to the testator. And again, where the agent has disposed of the gift, the subject of the request, out of the term of the agency given to him, and without the knowledge of the testator or the will maker. And thirdly, if the gift is still in the estate in substance, although the form has changed or the name has changed, then redemption will not apply. For example, you have moved that money meant for that purpose from one account to another and can be traceable, or that the shares of stock have actually changed name or changed form by virtue of the corporate name change, then the rule of redemption will not be applicable. Now, lapse of gift. Lapse of gift is another one that I want to note, that a gift is said to have lapsed when it fails for want of beneficiary. A gift is said to have lapsed when it fails for want of what? Beneficiary. When a gift cannot be given because all of the named beneficiaries, of course, including the contingent beneficiaries, have either died or disclaimed the gift, of course, the gift will lapse. I take that again. A gift is said to have lapsed when it fails for want of beneficiary. When a gift cannot be given because all of the beneficiaries that are named, including contingent beneficiaries, have either died or they have disclaimed the gift will lapse. When the beneficiary cannot be found or the gift has been disclaimed by the beneficiary, then the gift will lapse. So a lapsed gift, of course, is treated as though the testator had not made the gift at all, and the property, from the gift is instead distributed with residual estate. So what I'm trying to say is that a gift will become lapsed if they can't find any of the beneficiaries to inherit it, or that all the beneficiaries had actually, disclaimed the gift, and that gift will be treated as if the testator has not made that gift at all, and the property from that gift, of course, will be distributed, with the residual estate. So it forms part of residual estate when it has failed, when it has lapsed, when the beneficiary cannot be found, when it has been disclaimed. It will be taken that no gift of that asset has been made, and that it will fall part of the residual estate of the testator. Of course, if the gift that lapsed itself is a gift of residue, partial intestacy may arise. If the gift that lapsed is a gift of residue, then what that means is because the thing is part of residue. If provision has been made to how to make that residue, but it's now lapsed, then partial intestacy may result, and the gift may be, may instead pass under the laws of descent and distribution of intestacy. Of course, please note this very importantly, and then let me see what other things that I need to let you know. That when a beneficiary dies before the testator, the gift also fails and it lapses. When a specific demonstrative or general bequest lapses, the lapse gift simply becomes part of the residual estate. Please note, as I repeat, that when a beneficiary dies before the testator, the gift will do what? It will fail and it will deem to have been lapsed, And then when a specific demonstrative or general bequest, when they lapse, the gift work, they become part of the residual estate. And when a beneficiary, when a residuary bequest lapses and there's no backup or co-beneficiary, the residuary will be distributed under the rules of intestacy, to be distributed under the rule of intestacy, because the rule of intestacy don't always represent the wishes of the testator. It is best practice to name a backup beneficiary. Always name a backup beneficiary. Are we together? Always name a backup beneficiary. For example, you can say that, to my children who survive me, or if no children of mine survive me, then to my grandchildren who survive me. That's a way to draft a backup, to name a backup beneficiary. To my children that survive me, or if no children survive me, then my grandchildren who survive me. So abatement, you know what is abatement now? Abatement is the process of reducing the gifts given in a will because the assets of the estate are not sufficient to pay all the debts of the estate and also distribute the gifts as the testator intended. Okay, uncertainty, and then uncertainty, and then that's circumstances. We are talking about circumstances that can lead to failure of a gift. So, 1, redemption. 2, lapse. 3, we talk about abatement. Then number 4, we talk about number 4. No, number 4. What's number 4? Number 4, we talk about uncertainty. It says that a gift will fail due to uncertainty, where it is not possible to ascertain what the subject matter or the object of the gift is. Those are the circumstances, 1, 2, 3, 4 circumstances that can lead to failure of the gift. Number 5, we can see number 5. Number 5 says that where the beneficiary or their spouse attests to a will by virtue of section 15, section 15, are we together, of the Wills Act, by virtue of section 15 of Wills Act, and then by virtue of section 8 of Wills Law of Lagos State, deprive an attesting witness and their spouses or partner from receiving any benefit under the will which may attest. So which they attest. So they're saying that when you go to attest to a will and you are partner or you are beneficiary of, when you go to attest a will and you are beneficiary of that will, or you are the spouse of the testator, you will lose your gift, and then the gift made to you will fail. So listing again circumstances when gift made in a will can fail. It includes 1, redemption, 2, lapse, 3, abatement, 4, uncertainty. Number 5, that is when the beneficiary, or their spouse attests to the will. When the beneficiary or their spouse attests to the will. Section 15 of Wills Act 1837 and Section 8 of Wills Law would deprive an attesting witness and their spouses, attesting witnesses and their spouses or partner from receiving any benefit under the will which they attest. Of course, if the beneficiary or their spouse in an attesting witness is an attesting witness, the attestation itself will be valid. It will be valid attestation, but this will not cause, it will not cause the will to fail. Only that the gift to the witnesses or their spouses shall be void. See, Okonla. No, I can't pronounce them very well. Okay, I will spell it for you. OKOLONWAMU. OKOLONWAMU and another against OKOLONWAMU. Maybe I'll try to pronounce this. Okonlawamu. Okonlawamu. I can't really pronounce very well. It's okay. Let me spell it for you. OKOLONWAMU and another against OKOLONWAMU and others. Of course, the position is that when you are a beneficiary to a will, I get my point. You cannot attest that will. If you attest, your gift made to you and your spouse will be lost. You will not be able to receive the gift under that will. But what it means is that even though the beneficiary and their spouse, is an attest, they are attesting witnesses to the attestation, the attesting witnesses to the will, the attestation will not be invalid. It will not be invalid. It will be valid. It will not cause the will to fail. Only that the gift to those witnesses and their spouses will be void. So that is position in that case. I can also see the case of Ross versus Counter. See the case of Ross versus Counter, and then Now, other instances where a gift may fail include where the beneficiary is guilty of unlawful killing of the testator, and where the beneficiary disclaims the gift. We have mentioned all of these, and then please note very well that a gift will fail where there's an redemption, subject to exceptions to that rule. Redemption is when the gift is lost or thereabout. When there is lapse, that is when when there is lapse. That's when that's when the beneficiary cannot be found, or that the gift has been disclaimed by the beneficiary. Exception to redemption is where it has been removed by fraud or tortious act of a person that's unknown to the will maker, or where the agent has sold the property, in exercise of power that is above the power that has been given to him, without the knowledge of the testator, or where the gift is still in the estate substantially, but the name and form has changed. Those are the exceptions to the rule. For example, where the money in the account has been moved from one bank account to another. Of course, where the stock or the shares are actually changed name by virtue of the change in the company name. And then we also mentioned the fact that abatement where there's a reduction in the gift that is given to you by virtue of the fact that the estate is insolvent. Now, uncertainty of the gift, uncertainty of the gift or the subject matter or thereabout, or that where there is a beneficiary who is attesting to a will which will make himself and the spouse not to be capable of taking the gift made for them in that will, but their failure to take the gift does not mean that the attestation of the will be invalid. Another circumstance that could lead to gift failing is where the beneficiary is guilty of unlawful killing of the testator. Ladies and gentlemen, that brings us to the end of what do we call it? To the end of gifts. To the end of gifts. So next week, hello, are we there?
Sir, we can hear you.
Hello, sir.
So our course outline ends at classification of gifts, sir.
You say what?
Our course outline
is what?
Our course outline for this semester ends at classification of gifts, sir.
It ends there.
Yes.
I can trust you people. So what will you be doing with your time?
Revision, past question, those kind of tutorials.
Okay, no problem. But we can take it up from there next semester, but we'll find a way to deal with your class, your assessment. So that takes us to the end of, admission of essay. So the people that are doing conveyancing, hello, the conveyancing people.
Yes, sir.
Are you there?
Yes, sir.
Okay.
Yes, sir. We are here, sir. Yes, sir.
We're supposed to meet at 3 o'clock today. Is it 3 o'clock?
Yes, sir.
Yeah, by
3:30.
3:30. 3:30.
Okay. All right, no problem.
All right, sir.
Okay, no problem.